Morning, Minister.
Morning, Chair. Morning, the honorable members. Morning, everybody else.
Morning. I don't see the Deputy Minister.
Recording in progress.
He had challenges with the joining, but no problem. He will join us.
Yes, he'll be joining us. I think there are some challenges somewhere.
Okay. Good morning, Mr. Amaru and your delegation. Good morning, Executive Director IPIT and your delegation.
Good morning, Chair.
Good morning, Chair.
Good morning, honorable members.
Good morning, Chairperson.
Morning, Chair.
Good morning.
Morning, Mr. Simani.
Morning, Chair.
Good morning, Chair.
Yes. Good morning to everybody. I see we have stakeholders who have joined. Greetings to them. Our support staff, both from the ministry and Parliament, you are heartily welcome. Let's continue with our meeting. Let's flight. I can see on the system that we are in quorum. Let's flight the agenda, Babalo. There's the agenda. Adoption of the agenda, apologies, opening remarks. Adoption of minutes and public participation report. Matters arising. Presentation by the Civilian Secretariat. Further committee deliberations. Discussions and closing. If there's no amendment, can I request for a motion for the adoption of the agenda that will guide us today in this meeting? Honorable Gomba.
Honorable Chair, I move for the adoption of the agenda.
Thanks very much. Can I get a second? Honorable Marekwa.
I second, Chair. Thank you and good morning.
Thank you very much. Good morning. Is there any alternative view? Nothing. This is the agenda that will guide our meeting. Can I get apologies?
Good morning, Chair. Good morning,
Yes,
Chair. I received the apologies from Dr. Groenewald. The minister, he indicated that he will leave the meeting early at 10 o'clock.
Okay. Any other apology from the platform? Thanks very much. From Honorable Groenewald and Honorable Minister, who will be leaving early around 10 to attend to other commitments. I think those apologies are accepted by the meeting. Can we move to the third item, which is opening remarks by the chairperson? Maybe even before I go to my opening remarks, let me indicate that as per the program that was circulated to members, we are planning for an oversight in Limpopo. We're still at the planning stage. It might be Limpopo, or it might be Gauteng and Limpopo. But we are also planning, together with that oversight, to meet with the provincial commissioners. We hope everything will be fine. Now, there's a form sent to members who will form part of the oversight from the 1st to the 4th of December to fill in that form, sign it, and send it back to Babalwa, our committee secretary. That is as per the instruction of the House chairperson, that whenever we arrange oversights, we need to have members agreeing to attend by signing that form. So we'll urge you all members to make sure that you sign the form and send it to Babalwa so that the office is able to plan accordingly. Honorable members, last week, the Civilian Secretariat and IPIT briefed us on their responses to public submissions. And our legal advisor, Mr. Simani, briefed us on his opinion on the inclusion of the national preventative mechanisms under the OPCAT. Our content advisor has developed a revised program for processing the bill in the event that we decide to extend the scope of the bill. This document was circulated to members last week, and I trust that members had time to peruse the document. As a committee, we must find consensus on whether to extend the scope of the bill, and with that, request permission from the National Assembly. As lawmakers, we must be cautious against the fragmentation of legislation and thereby create a situation where the implementation of OPCAT is dealt with in different pieces of legislation. Ideally, there should be one cohesive piece of legislation to give effect to the convention. Today, we are engaging in detailed deliberations on the bill and must highlight where amendments are required. The Secretariat will present a revised version of the bill and will also put forth arguments on the inclusion of the OPCAT mandate. The clause-by-clause deliberation scheduled for this coming Friday must enable the department to draw up the A-list or A version of the bill. The consideration of the A-list next week, Wednesday, will allow for it to be incorporated into the bill, which creates the B version of the bill. This is the version that the committee will adopt and forward to the National Assembly for adoption. Thanks very much, honorable members, for your commitment to deal with the bill. May we continue to have fruitful engagements during today's meeting. Then we move to the next item, which is the
Chair.
item. Hello.
Hi, Chair. It's Honourable Whitfield. I had my hand up. May I proceed?
Oh, okay. Okay, I didn't see you. Sorry. You
No, that's
proceed.
fine. Thank you. Just very briefly, just with respect to the oversight and with respect to all members of the committee, I don't think that it is reasonable to say that we are going on an oversight either to Gauteng or Limpopo without knowing what the oversight will be about and how it relates to previous or current work of the committee. If we can have an explanation of that, and I certainly don't think you can solicit from members their agreement to participate in something we don't have an explanation of, nor do I think it's reasonable to say at this late stage, which is now what, 2.5 or 3 weeks, 3 weeks until the oversight, that you have not decided yet what the destination will be. There are logistics involved. There are busy diaries that need to be coordinated. And so I think the committee needs to know what the purpose of the oversight will be, either in Limpopo or in Gauteng. And I think it would be appropriate for the decision to be taken on the destination this week. It's not fair to ask members to blindly accept oversight with not knowing what the purpose of that oversight will be and what it is we hope to achieve at the end of this 6th Parliament. Thank you.
Thanks very much, Honorable Whitfield. That explanation will be sent to members before the end of this week, but the destination is Limpopo. What we thought is before we proceed to Limpopo, if all things go well, we could have a session with provincial commissioners, but the destination in Limpopo. But thanks very much for your input. The office of the chairperson will send a thorough explanation. The objective is to visit police stations, especially police stations that are under construction. See what the police station in Moyeshe, police station in Gapane, and the police station in Mankweng, especially that there's been construction of those police stations. They're not yet completed. We are told in Moyeshe the police station will be completed very soon. In Gapane, the provincial commissioner briefed us in our last meeting. And Mankweng also, there's an intention to construct, but Mankweng, you remember, was at some stage part of the top 30 police station. But the destination is Limpopo. But there will be a thorough explanation sent to members before the end of this week from the office of the chairperson. Fine, Honorable Oldfield.
Thanks, Chairperson. I mean, that helps us to take an informed decision. Would there be a report on that oversight that is tabled in the 6th Parliament still, given the fact that we're at the end of the 6th Parliament and there are probably only 2 months left to process it at the beginning of next year? What is the indication? And that would be my only question, final question. Thank you.
Yeah, we'll do our best to make sure that we table the report as this committee of the 6th administration, so that we clear almost all of what we are supposed to do. Thanks very much.
Chair, I'm sorry.
Honorable Telblanche.
Chair, I'm sorry to interject. I tried to raise my hand. It looks like DM is waiting to be accepted.
Oh, DM, is in.
Yeah, I don't know if he's in, but I spoke to him and said he's waiting to be accepted in the meeting.
Okay, I see. Honorable DM, are you in? DM? I see on the platform is in, but possibly is a network problem.
Sorry for interjection. Okay.
Babalwa, work on that, assist the DM. Honorable Terplanch.
Chairperson, thank you. Thank you also that, I heard that you said that we are going to get the information shortly, and thank you for that once again. I just want to ask, apparently those are police stations under construction at the moment, briefly as you explained, and my question then is, are we going to get an explanation also from the Department of Public Works, where exactly, what is the progress regarding those police stations? And just lastly, on the very same issue, are we going to, will Public Works also have representation when we visit the different building sites or police stations, whatever the case may be? Thank you, Chairperson.
Chairperson.
Thank you, Honorable Terplanch. That is the intention, to make sure that we get a thorough explanation as this committee. Where work has been done, where work is not completed, you get a thorough presentation. But you'll get that whole information. Honorable Gerike?
Yes, Chair, good morning. Can I rise on a point of order, please? Can I propose that we stick to the agenda? The points raised by the honourable members is not on the agenda at the moment. You have made it clear that you will communicate to the committee with regard to the oversight visit. And therefore, when you communicate, members may ask their questions. Can we stick to the agenda, please? Thank you very much.
Thank you very much, Honorable Gerike. I think members have been answered. Let's continue with the agenda. The next item. What is the next item, Babalwa?
Good morning, Chair. It's Nicolette here. The next item is the adoption of the committee minutes of 1 November.
Yes, let's fly to the minutes. Babala, can you assist the Deputy Minister? I think he's struggling.
I think IT is beating him, Chair.
Okay. Good morning, Honorable Shekima.
Good morning. Our Deputy Minister is a practical person.
Okay. There are the minutes, honorable members. This is the agenda. Can we move on? It's the roll call, opening and welcome. Opening remarks by the chairperson. Consideration and adoption of minutes, matters arising. Opening remarks by Deputy Minister, presentation by legal advisor, Civilian Secretariat, IPIT, committee deliberations, committee resolutions. During discussions, the committee took the resolutions that the parliamentary legal advisor and content advisor should prepare a comprehensive document to advise the committee regarding the process going forward, together with timeframes on the IPIT amendment bill. If the committee decides to extend the scope of the amendment bill to include provisions that give effect to the optional protocol to the Convention Against Torture and other cruel, inhuman, and degrading treatment of punishment. The committee suggested the cancellation of the meeting, which was scheduled for Friday, 3 November, to allow the officials to have sufficient time to gather the information which must be presented in the next meeting on Wednesday, 8 November. Closing remarks by the chairperson, and the meeting adjourned at 11:30. Those are the minutes. Are there amendments?
Chairperson, my hand is up.
Honorable Whitfield.
Chairperson, during the course of the deliberations, I raised the query whether my comprehensive inputs, which were forwarded to the previous chairperson who invited comment from the committee at the time into this bill and the process, whether those were ever provided to the Civilian Secretariat. You confirmed that I should send those to you. I provided them to the committee researcher, to Nicolette, And I just want to confirm that that finds expression in the minutes. I don't see it in the minutes, but it is critical that it does find expression, because I think that the written submissions of members, which were solicited by the former chairperson, there should be some expression to that in the minutes, and then perhaps just to confirm whether in fact you did receive those. Thank you.
Okay, I think let there be expression, because I remember we agreed that Honorable Whitfield resent the submission. Of course, the submission was resent, and the submission was even forwarded to Secretariat. Let's just have it in the minutes. Any other amendment, Honorable Terplanch?
Chairperson, yeah, please can I just request, can we just scroll up back to the name list, the people attended the meeting? I just want to make sure about something there, please. I missed it now. It's not, okay, not visible yet. Okay, just a moment, Chairperson. Yeah. Okay, thank you, Chairperson. I'm covered. Thank you.
Thank you very much. Are there further amendments? You can lower your hands, Honorable Whitfield and Branch. If there are no further amendments, can I call for motion to adopt the minutes? Can I get a motion?
Sheikh Imam supports, Chair, moves for the adoption.
Honorable Sheikh Imam moves for the adoption. Can I get a seconder?
Seconded, Chairperson.
Comrade Molekwa second the adoption of the minutes. Is there an alternative view? No alternative view. Minutes adopted. The next one is 4.2, consideration and adoption of public participation report. Can we have the report? Here's a draft report, honorable members. It was sent to all members well in advance, and I guess members have gone through it. Introduction, objectives of the amendment bill, constitutional mandate and parliamentary rules, public participation on the IP amendment bill, public submissions received by the committee, public hearings held by the committee. Let's scroll up. Clause by clause summary of public submissions, objects of the amendment bill, let's scroll up. Scroll up. Response from the Secretariat. Let's scroll up. Let's scroll up. Thank you. As part of conclusion, Parliament's Portfolio Committee on Police is satisfied with the positive and detailed discussion that took place during public hearings. The committee expresses its gratitude to the organizations and individuals that made submissions on the IPIT Amendment Bill and reiterates the importance of public participation when Parliament deals with the legislation. Can I get a motion for the adoption of the report so that it can be submitted to the National Assembly? There's the report, unless if there are issues. Honorable Shegima.
I move for the adoption. Thank you.
Honorable Shegima moves for the adoption. Honorable Gomba.
I second the adoption of the report, Chair.
Honorable Gomba seconds. Thank you. Honorable Terplanch.
Chairperson, I just want to put it on record that we reserve our rights, please.
Thank you very much. Any other party that would like to reserve the rights? Thank you very much. The report is adopted. We'll put it on record that DA reserves their rights for now. Can we move to the next item?
Sorry, Chair.
Honorable Majosi.
My apologies, Chairperson. Good morning, Chair, and all honorable members, the Minister and the DM. I can't, my icon for raising my hand, I'm not sure what's happening, it's stuck. I think my iPad has a problem. But as the IFP, we don't reserve rights, but would like to revert back to the caucus and then get the mandate. Thanks.
Thanks very much, Honorable Majosi. Thanks very much. The next item, as I recall, is matters arising. I think on matters arising, issues that were resolved by the committee, it is what will be the content advisor has sent a document as resolved by the committee. The submission by Honorable Whitfield has been received both by the Office of the Chairperson and the Office of the Acting Secretary. So we'll deal with the issue of timelines as resolved by the committee. Unless if there are other matters arising. but those were the issues. Nothing. What's the next item? The next item is presentation by the Civilian Secretariat for Police Service, after which we'll have further deliberations. Minister, we're in your hands. Honorable Minister. Honorable Minister. Okay, if the minister is not available, Honorable Deputy Minister.
Chair.
Oh, thank you.
Yeah.
Thank you,
Chair,
Minister.
it does look like the issue of connectivity is quite big. Now and again you're on in. It also does it with telephones. We just cut. We don't know what's happened with connectivity and the signals and all that. But Chair, as I've made a request, I have some pressing issues at 10. One is glad that he's here. We see his progression in here. But Chair, I would want to be fair on this one. The focus here is under the DM, and I'll request through you, Chair, the DM to do us the opening and the preliminaries on this one. I hope he is on the platform by now.
Thank you, Minister. Deputy Minister.
Yeah, no, thanks, Chairperson. Thanks, Minister, for the opportunity to present. Yes, indeed, we have been interfacing with the committee since the introduction of the bill to Parliament and the public hearing processes. We want to appreciate that opportunity that the committee has afforded us throughout the processes. Today we are expected to come back to the committee and further engage with the committee on the presentations that have been received so far. I will request that we allow the acting secretary and the team to take us through. We are joined, chairperson and committee members, by the acting secretary and the legal section that have been handling this, led by Advocate Don Bell, working together with the leadership of IPID, led by the Executive Director, Mentateng, and the legal division within IPID. They've been working together on these matters, but IPID is also joined here on the platform by the management of the institution. If you may allow, Chairperson, we can request the secretary and the team to lead us on the issues that OPCAT raised and our members raised as well, so that we present our responses to those issues. Acting Secretary, through you, Chair.
Thanks, DM, Honorable Chairperson, Honorable Minister, Honorable DM, Honorable members, all present. I want to indicate that we have prepared two presentations. One is dealing with the OPCAT, as the Deputy Minister has indicated, where we are outlining our recommendation or proposal on and view on the matter. But we have also prepared now the presentation on the bill, on the actual bill, which has taken into consideration the public comment, which is in preparation for the clause by clause. And check there also to do that presentation today or on the day of the clause by clause. Chairperson, I also want to confirm that last week we indeed received the letter from Honorable Whitfield which we have also duly taken into consideration. So without necessarily responding to each and every aspect that he has raised separately. So when we do the presentation in terms of the details of the bill, we to give the specifics on each of the clauses that he has commented on. So in that regard, Honorable Chairperson, and through you, I will request Advocate Bell to take us through the presentation on the OPCAT presentation.
Thank you, Advocate.
Good morning, Chair, Honourable Minister, Honourable DM, all honourable members, colleagues and stakeholders. I am going to take you through the response that we have on how we dealt with the OPCAT and the NPM obligations. So I'm on slide 2 now. And so the proposals were made during public comments to incorporate the preventative monitoring function of the National Preventative Mechanism, known as the NPM. The NPM is an independent mechanism for the prevention of torture, designated or established in accordance with Article 18 of the Optional Protocol to the Convention Against Torture, cruel, inhuman, or degrading treatment or punishment, and it's shortened by the name of OPCAT. In terms of the protocol, state parties are required to establish a system of regular visits to places where people are deprived of their freedom in order to prevent torture and other cruel, inhuman, or degrading treatment or punishment. Parliament has ratified the OPCAT in 2019. However, there is no domestic legislation or act currently that regulates the NPM. The members of the NPM are South African Human Rights Commission, Judicial Inspectorate for Correctional Services, Military Ombud, IPID, and Health Ombud. All these institutions are enjoined to enforce, observe, and promote OPCAT obligations. Next slide, please. In the absence of legislation, there are agreements that have been concluded with IPID, the military, and the Judicial Inspectorate for Correctional Services, which enable the parties to report on these matters within the context of the OPCAT obligations. The mandate of IPID, Chair, is in terms of Section 206(6) of the Constitution, and it is limited to the oversight of SAPS and the MPS. So the inclusion of OPCAT obligations in the IPID Act would limit the oversight of the effectiveness of NPM to that of SAPS and MPS members only, whereas there are other parties or bodies that require oversight to be monitored in terms of NPM prescripts, such as correctional service facilities and centers, hospitals and medical care centers, immigration holding facilities, road traffic management officials, and soldiers. There are a number of parties that enforce, observe, and promote OPCAT obligations, and therefore any legal provisions regulating such should be inclusive in one piece of legislation as a whole and not dealt with piecemeal. Next slide, please. Furthermore, Chair, Clause 16 of the bill, Clause 16(1)(f), provides for investigation of complaints of torture in terms of the Prevention and Combating of Torture of Persons Act 2013, as well as assault GBH by members of SAPS or MPS as prescribed. So that as prescribed is a new addition that we have done to the bill now. And so this will provide for how to express and to align to OPCAT obligations in regulations to give effect to the convention. In addition, Section 7 and subsection 9 of the IPID Act also provides for investigations of offences allegedly committed by SAPS and the MPS, and this would include torture and assault GBH. Firstly, Chair, There is a unit also that conducts regular cell inspections and reports on matters, amongst others, torture and assault, to the Executive Director on a monthly basis. Reports are also submitted on a quarterly and annual basis to the Minister, as well as the Portfolio Committee on Police. And secondly, IPID has revised the cell inspection tool norms and standards to be aligned to the NPM or OPCAT tool. Chair, it is important to note that the non-inclusion of IPID's NPM obligations in the current process of the review of the IPID Act will not cause any prejudice, as IPID already conducts regular inspections of police cells and reports on it. This obligation, Chair, is also provided for in IPID's annual performance plans and in their key result performance areas. IPID also reports on the implementation of the obligations on a quarterly basis. This, Chair, is a clear indication that IPID is currently fulfilling the OPCAT obligations in terms of the oversight of SAPS and MPS. So in view of the above, it is therefore recommended that MPN OPCAT obligations should not be included in this bill, but rather to include it, for example, in the Prevention and Combating of Torture of Persons Act 2013, alternatively in a new bill. In conclusion then, Chair, it is therefore reiterated that the insertion of OPCAT obligations should not be limited to the IPID bill, but should find expression in the Prevention and Combating of Torture of Persons Act or in a new piece of legislation as stated above, for the general application of these obligations by all relevant parties to the NPM. It is therefore recommended that the Portfolio Committee on Police considers the proposal not to include MP and OPCAT obligations in this amendment bill. Thank you, Chair.
Thanks, Honourable Chairperson. That will be our presentation.
We will await your guidance in terms of whether you want us to do this law presentation. Thank you.
I can't find that.
Thanks very much. Thanks very much. Maybe for a proper flow, before you present the other part, Secretary, let's get a presentation from our content advisor so that we are able to have a proper flow with regard to OPCAT. Then immediately thereafter, you'll then be able to present the other part.
Yes, Chair, if you may allow just a comment.
Yes, DM.
Thank you very much. I think on what I want to recommend, Chair, as an addition to the recommendation in terms of what the advocate Bell recommended there is that the committee should consider a meeting with the relevant committees that the Act, the combating of the Prevention and Combating of Torture of Persons Act of 2013, and the other role players, that is your Committee on Defense and Correctional Services, have a discussion on how an amendment to the Torture Act of Persons Act can be effected, or the processes of introducing the new bill. How can that be effectively handled? Because we don't want a situation wherein it seems like we just want this thing to disappear. We are not keen to follow the processes that will ultimately lead to addressing the issues that were raised, because like it is very clear that you need a multidisciplinary approach in responding to the proposals that have been raised, and the Committee on Police alone, it can't process that, but a joint process can be appropriate for that particular purpose, so that we also show that there is indeed an intention on the side of the lawmakers to take the process further. I just thought I must add that dimension, Chair. Thank you very much.
Thanks very much, DM. Thanks very much. Can we then request our content advisor to present as per the resolution of the committee? Then thereafter, Secretariat will come with the rest of the presentation.
Good morning, Honourable Chairperson, Honourable Members, Deputy Minister, and everyone on the platform. Chair, as per the resolution, I'm just going to share the document that I prepared for the members last week. So I'm not going to go into detail on what the OPCAT and the MPM entails, as the Secretariat already alluded to that. I will focus on the parliamentary process based on the legal opinion that we received, just as a reminder. Honourable members, as Mrs. Samani said last week, if the committee decides to extend the scope of the IPIT bill to include the OPCAT mandate, we will need to request permission from the NA under Rule 2864 sub B. And then once we have received permission from the NA, we should include the provisions and then republish the bill for public comment. And Mrs. Samani gave a good example of, or he cited a case where Parliament was taken to court for failing this duty. Honourable members, just as a to note that the costing involved in advertising for public comment, the last round of publications, it came to 132,548,000 rand. And gee, that is for publication in a national newspaper as well as 8 regional newspapers in all official languages of South Africa. Chair and honourable members, in terms of the revised time frame, if the committee decides to extend the scope of the IPIT bill, the provisional adoption date is then moved along to mid-March 2024, just before the Parliament's term expires, before the general election. Honourable Chair members, the revised time frame unfortunately does run the risk for the bill to lapse either in the NA before the second reading debate, or it will definitely, I want to say definitely, lapse in the NCOP. Chair, and just when I say this, before I go to this, the revised time frame, I want to again draw members' attention to Mr. Samani's presentation of last week, where he cited the Constitutional Court judgment in the case brought against the Speaker of the NA and others by the Doctors for Life International. Chair and honourable members, the judgment stated very clearly that in terms of reasonableness for the for public participation towards the legislature in the lawmaking process, the saving of money and time constraints in itself does not justify inadequate opportunities for public involvement in the parliamentary legislative process. Chair, so based on that, any deliberation or decision taken on the OPCAT mandate must be done solely on merit and not on the time constraints or budget. We have sufficient funding available, and there's also sufficient time available in the remaining parliamentary calendar up until mid-March next year to process the bill through the National Assembly. Chair, just to highlight, if a bill lapses, it is revived in the next parliament at the exact point where it lapsed. So, in other words, Chair, there will be no additional costs, so there will not be a repeat of public participation or advertisement or anything. So it will just merely be revived at the point where it lapsed. Chair, honourable members, just to go to the detailed revised time frame for the processing of the bill, the committee should ideally then reach a decision as soon as possible, preferably by next week, on whether to include the obligations under OPCAT. On the 17th of November, it is proposed that the committee consider and adopts its report to be submitted to the National Assembly to extend the scope of the amendment bill. On the 22nd of November, we are hoping to get the report on the order list of the NA. Chair, but unfortunately, this is not within the purview of the committee to schedule the order list or the order paper of the National Assembly, but we will endeavour from our side to encourage the NA table staff to push it up above the line as soon as possible. Chair, and then based on the legal advisor, he indicated that the bill must be republished for the exact same time as the original version was tabled. So that will happen from the 1st to the 22nd of December. Chair, and then, so the publication will run into the NA leave period and constituency period, which is scheduled from 18 December to the 5th of January next year. It is proposed that on the 24th of January next year, we will have further public hearings on submissions focused on the OPCAT. The 31st of January, we will have departmental responses. The 7th of February, we will adopt a second public participation report. On the 14th of February, we will engage in committee deliberations, which will run also on 16th February. And then on 21st February, we will do the clause by clause. 28th February, we will adopt the A list or the A version of the bill. And then on 6th March, we will adopt the committee report on the amendment bill and the bill in its entirety. Honourable members, based on the previous election year in 2019, it is expected that Parliament will rise in mid-March next year. So, Chair, just to quickly also, Chair, basically that is the amended time frame. So as I mentioned previously, we have sufficient time available to process the bill if we decide to extend the scope of the bill. There's enough time, there's enough money. Chair, yes, so as I state here, and as I stated earlier, the consideration of the to extend the scope must be based on merit alone and no other factors. But Chair, if I can just quickly also go through the reasons that I have put forth why not to include the OPCAT in this current revision of the IPIT bill, is, as the Secretariat stated, the oversight functions of IPIT are limited to the South African Police Service and the Municipal Police Service. So if we choose to extend the scope, it must be made very clear that this mandate is exclusively focused on the SAPS and Municipal Police Service and does not extend to JICs or the Military Ombud or the Health Ombud, where they may detain persons or deprive them from liberty. Chair, and as you mentioned in your opening remarks, the inclusion of preventive custody monitoring in the bill does run the risk to fragment the approach to the implementation of the OPCAT, whereas in dealt with in different pieces of legislation. And Chair, as you mentioned, it should ideally find expression in one cohesive piece of legislation, either in the Torture Act or a completely different piece of legislation to bring into effect the OPCAT. Jane, just as a concluding remark, as Secretariat also mentioned, although the IPA does not fully have the capacity to implement preventative custody monitoring, the Directorate is currently fulfilling that mandate in cooperation with the South African Human Rights Commission. It might not be complete or fully, but the Directorate has confirmed that it definitely is doing this mandate and have even amended the station monitoring tool to adapt and adhere to the NPM or OPCAT standards. Thank you, Chair.
Thank you very much. Thank you very much, Nicolette. I guess members are taking notes so that when the time comes, we are able to deliberate. Unless if Mr. Simani, you want to say something with regard to this? Do you have something?
No, not at this point, Chairperson. Not at this point. Thanks.
Thanks very much. Then we can continue with the presentation by the Secretariat. Nicolette will also come back to complete her presentation. Secretariat. Can we continue, Secretariat?
Thank you, Chair. Sorry about that. I was just having a glitch with my laptop and trying to unmute. Okay. I'm ready to go now. So I'm going to take the members and all stakeholders that are on the platform through the IPIT bill again, as was presented on Wednesday. So if we can skip the slides up till clause 1, and that's on 6, slide 6, because the rest is all water under the bridge now. So I'm going to start, Chair, with Clause 1, the definitions. Clause 1 of the bill seeks to amend Section 1 of the Principal Act through the insertion of certain definitions, such as the definition of firearm, municipal manager, and executive head of the municipal police service. Chair, this section has also been reviewed in order to take into account a proposal in the public comments to further clarify the role and function of IPID by defining the meaning of operational and institutional independence. Also in line with this is also in line with the Constitutional Court judgment in the McBride matter. Clause 2, Chair, deals with the establishment, and it amends Section 3 of the Principal Act, which provides that the Independent Police Investigative Directorate must exercise its functions in accordance with the Constitution. Next slide, please. Clause 3, Chair, deals with the independence and impartiality, and this clause seeks to amend Section 4 of the Principal Act. It provides that the Directorate is institutionally and operationally independent and must exercise its powers and perform its functions independently and impartially, without fear, favor, or prejudice or undue influence. And this must be in line. This is also in line with the Constitutional Court ruling in the McBride matter. Chair, it's important to note that a proposal was made in the public comments for the amendment of the Constitution in order to fortify the independence and impartiality of IPID by elevating it to a Chapter 9 institution. Chair, this proposal was considered. However, it was decided that this is a matter that needs a policy decision and consideration by Cabinet, as IPID is a fully fledged government department with the Executive Director as its accounting officer. It also has its own budget, which is appropriated by Parliament, and it is not dependent on any other source for its budget. Next slide, please. Chair, I'm going to go clause by clause with this, with clause 4, subclause by subclause, and this deals with the appointment of the executive director, and it did elicit a huge amount of comment. So, in response to the concerns of the public comments regarding the lack of parliamentary oversight over the processes for appointment of the executive director, Section 6 of the Principal Act has been amended. Chair, just also as a reminder, as Acting Secretary said earlier on, it also deals with the concerns that were raised by Honourable Whitfield in his letter that we received a few days ago. The result is that subsections 1 and 2, which provides for confirmation of appointment of the executive director by a relevant parliamentary committee, has been retained. I would also like to pause at this point to read out clause 1, if I may. Clause 1. Clause 1 states, Chair, that the Minister must nominate a suitably qualified person for appointment to the Office of Executive Director to head the Directorate in accordance with a procedure to be determined by the Minister. By emphasizing in accordance with a procedure to be determined by the Minister, Chair, this provides that the Minister may appoint a panel to assist in the appointment. And Chair, this has been the practice over the years. The Minister has a panel which assists him with the shortlisting, interviews, nomination, and recommendation to the Parliamentary Committee for confirmation or rejection of the candidate. The remainder of the subsections of Section 6 from 3 to 5 in the Principal Act have been strengthened. So they are not retained as they are. We've strengthened those. So the removal of the Minister to nominate a suitable person, the department agrees with Honourable Gericke's view not to vilify the Minister by arrogating his or her powers, and therefore the role of the Minister as the executive authority over IPID and its administration remains as contained in the Constitution and the national legislation, which is the IPID Act. There are checks and balances for oversight on appointment, and it is not the intention to overburden the Parliamentary Committee with the appointment of a panel, and furthermore constituting the panel will lead to an undue delay with the appointment, which time frame is now 6 months and no longer a year. Next slide, please. So the proposal for the period of appointment has been reconsidered and revisited and revised to that of a fixed period of 7 years, which is non-renewable, to provide for certainty and not open to numerous interpretations. The proposal that the remuneration of the executive director should be set to a statutory minimum has not been accepted, as there are administrative processes that deal with.
The slide is not moving, Advocate. Sorry, Chair. The slide is not moving. It's still on the 6-month period.
Oh, there's a sound there.
How is it moving?
On my side, it has moved. I don't know other members.
Can they please sort that out?
Okay, if it's moving on your side,
on mine
it's
it says stop sharing.
I was concerned about that. If it's moving on your side, we can proceed because I have a hard copy.
Other members?
Who else can Nicolette or
No, Chair, it's also not moving on my side.
Okay. Let's try to fix that. Honorable Ted Blanche?
On my side is also moving. I'm not sure if there may be network challenges with other people in the platform.
Okay. Let's continue because it does not affect everybody, but because the
thank you, Chair.
The presentation has been sent to members. Let's try to use both so that we don't waste time. You can continue, Advocate.
Okay. I'm not sure where I left off. I think it was with the proposal that the remuneration of the executive director should be set to a statutory minimum and has not been accepted, as there are administrative processes that deal with such issues outside of an act. IPID is a government department and not a Chapter 9 institution. The executive director falls under the predetermined public service salary structure. Between the two ministers that are mentioned in the bill, consensus can determine the notch within the salary structure. Therefore, there is no deviation. Chair, any deviation in terms of lowering the salary will attract legal ramifications. As a government department, IPID reports to the minister, and therefore he or she has the authority and the responsibility to ensure that IPID operates uninterrupted by when a vacancy is created, which is usually filled by a chief director within the directorate and not an outsider. And this will be done with the concurrence of the relevant parliamentary committee. The time frame has been changed from not exceeded 1 year and must be filled within 6 months. This is considered reasonable given all the administrative processes to be followed. That, Chair, would include the publication of the advert, the shortlisting, the interviewing, and eventually the appointment and whatever tests that person may have to be subjected to. I'm on slide 10. Clause 4, which deals with the responsibilities of the executive director. Chair, this clause seeks to amend Section 7 of the Principal Act in order to ensure that recommendations, and this word replaces complaints, regarding disciplinary matters which involve certain provincial and national executives are referred to all appropriate authorities, including the municipal manager and the executive head of the municipal police service. This is in order, this is in response to a proposal in the public comments that a reference should be to the recommendations in order to bring the bill in line with Section 30 of the recommendations. The clause has been amended further in order to provide for initiation of investigation by the Executive Director upon becoming aware of a complaint against a member of SAPS or the Municipal Police Service, and not only upon receipt of a complaint. Slide 11 deals with Clause 6, and that's the composition of the National Office. And Clause 6 provides for the deletion of Section 8.1 of the Principal Act, which deals with the composition for the National Office of the Directorate, as it is a matter that can be dealt with through IPID's internal policies and procedures. It also amends how and by whom the pre-employment security screening investigation should be conducted, and this is by the Directorate and not by the State Security Agency as provided for in the Act. Chair, this is because the security screening deals with criminal records, criminal checks, or authenticity of qualifications, which can be conducted internally by IPID. Slide 12 deals with Clause 7, and that's the functions of the National Office. It amends Section 9 of the Principal Act, which provides for the identification and a review of legislative needs in consultation with the Secretariat, and the reporting on such matters is to be made to the Minister and not to the Secretariat as provided for in the Act. Chair, I just want to also further have note that the Civilian Secretariat for Police Service is responsible for drafting legislation in the police portfolio in consultation with the department concerned. Chair, if I can just point out, recently the Civilian Secretariat, together with the relevant members of SAPS, recently brought before this very committee 2 bills which have been promulgated into law around December 2022. And these acts are both implemented by the SAPS. Clause 8 deals with delegations, and it amends subsection 3 of Section 10 of the Principal Act through the deletion of reference to Section 7.9, which in order to empower the Executive Director to delegate the initiation of investigations of any offence allegedly committed by a SAPS or MPS member to the provincial heads of the Directorate. So they don't have to come all to National Office. It can be dealt with in the provinces where it originated. Clause 9 on slide 13 deals with the composition of the forum. This seeks to amend Section 16 of the Principal Act through providing that a person, a representative from government, a department or institution may be invited to the forum if a particular matter concerns such a person, government, department or institution. Chair, I just want to add that this means that where there are questions around certain issues pertaining, for example, either to NPA or SAPS, which negatively impact on certain functions of IPID, the relevant officials from the NPA or SAPS, as a case may be, will be invited to attend a meeting of this forum. This is so as not to be prescriptive in an act concerning other entities, institutions, or departments. Chair, Clause 10 deals with provincial offices, and it repeals Section 19 of the Principal Act, which sets out salary levels of principal heads and the Directorate. It is considered not necessary to provide for such matters in this Act. Slide 14, Chair, deals with Clause 11, responsibilities of provincial heads. And it provides for a deletion of paragraph M of subsection 1 of 21 of the Principal Act, which provides for the preparation of financial statements by provincial heads of IPID, as in practice, such statements are prepared only by the National Office. Clause 12 deals with the appointment of investigators. So Section 22 has been amended in order to address the concern in the public comments that the deletion of qualification requirements of IPID investigators shall have the effect of juniorizing the level of entry for investigators, which is considered to be the backbone of IPID. Therefore, the proposal is that a person to be appointed as an investigator must at least have a grade 12 certificate or equivalent and a relevant diploma or degree. Slide 15. The clause also provides for the conducting of pre-employment security screening of investigators by directors. And this, Chair, would also involve the credit checks, criminal records, and authentication of qualifications as well. Clause 13, Chair, deals with the remuneration and conditions of service of investigators. This clause seeks to amend Section 23 of the Principal Act. It provides that the conditions of service, including salary and allowances payable to investigators, shall be determined by the Minister in consultation with the Minister responsible for finance. Concern was raised in the public comments that this proposed amendment creates a serious precedent for salaries of certain officials to be determined by ministerial decree, whilst the majority of public servants enjoy the right to have conditions of service to be determined through recognized collective bargaining structures within the public service. Slide 16 continued. This concern was considered. However, it is not accepted as IPID investigators are appointed in terms of the Principal Act and not in terms of the Public Service Act, and therefore have a different compensation dispensation. They are also members of labour unions, Chair, who would ensure that their labour relations matters are catered for. And furthermore, Chair, there is a special unit within the General Public Service Sectoral Bargaining Council that deals with investigators' labour issues. Clause 14 deals with the functions and investigative powers, and it provides for the insertion of paragraph B capital A in subsection 2 of section 24 of the Principal Act in order to bestow upon IPID investigators the powers to take buccal samples in terms of the South African Police Service Act 68 of 1995. Furthermore, amendments seek to address the concern in public comments relating to the fact that the bill provides for inadmissibility of criminal proceedings of self-incriminating answers, as this nullifies the purpose of other proposed amendments to Section 24, as a person questioned is free not to answer self-incriminating questions. Chair, just to add to the proposal arising out of public comments to amend Section 24(5) along the lines of the NPA Act cannot be considered because the questioning by IPID investigators differs from that of the NPA in that the NPA's questions relate to criminal proceedings, whereas those of IPID are for purposes of conducting investigations. Slide 17. The clause further provides for the insertion of paragraph 6, 7, 8, 9, 10, and 11 of this section of the Act in order to strengthen the provisions relating to investigative powers of IPID investigators, such as by empowering them to subpoena witnesses to appear before them for the purpose of giving evidence under oath. Chair, the consequences for the failure to comply or cooperate with IPID investigators are provided for in Section 4, subsection 2, Section 29, subsection 2, and Section 33, subsection 3 of the Principal Act. Clause 15 deals with the limitation of liability and proposes the insertion of subsection 2 in Section 27 of the Principal Act, which provides for the limitation of liability of officials of the Directorate. Chair, this amendment is in line with other legislation, for example, Section 5, subsection 3 of the Public Protector Act. Section 16 deals with the type of matters to be investigated, and it seeks to amend subsection 1 of Section 28 of the Principal Act in order to provide that the Directorate shall investigate the crimes of rape and murder, whether they have been committed on or off duty. This is continued on slide 18. So paragraph B, in paragraph B, the regulation 4 sub 1 provides for investigation of death of a person in police custody or death as the result of police action or omission. Regulation 4 sub 1 provides for investigation of the death of a person in police custody or the death as a result of police action or omission or both. In paragraph C, the complaint of a discharge of an official firearm by a police officer is repealed. The amendment to paragraph F, amendments to paragraph F are in order to provide that IPID shall investigate allegations of assault only if it is committed with the intention to cause grievous bodily harm. Concerns were raised in the public comments regarding the deletion of a provision on investigation of complaints of assault. A proposal was made to retain the investigation of assault complaints by IPID, as not only is assault an abuse of power, but the distinction between assault common and assault with the intent to cause grievous bodily harm, GBH, is often subjective and only based on visible injury. Common assault is not automatically precluded, Chair. As a recourse, it can be held in terms of Section 7(9) of the Act. The Standing Operations Chair, IPID, will conduct a screening of assault matters and determine which ones will require further investigation and are not as a result of minimum force used to effect arrest. Next slide, please, 19. This is further strengthened by what is contained in the J88 form that is usually filled out by a doctor. The investigation of all common assault matters diverts IPID from conducting investigations of priority matters. And according to a stakeholder chair who extracted statistics from the IPID annual report 2022-2023, there are 2,563 investigations for discharge of an official firearm and 11,876 investigations for common assault, and this constituted 80% of IPID's workload. The words "as prescribed" have been added to make provision in regulations on how to express in line with OPCAT in order to give effect to these obligations. Paragraph G provides for the referral of corruption matters by a national commissioner or the appropriate provincial commissioner, national head, or the appropriate national head of the Directorate for Priority Crime Investigation, executive head of the relevant municipal police service, and the municipal manager. Attempted murder in relation to the discharge of a firearm has been inserted as a new paragraph G, capital A. Chair, the paragraph has been further amended to take into account a proposal in the public comments that attempted murder should not be limited to the use of firearms only, and as a result, the wording "through the use of any weapon or instrument" has been inserted in paragraph G, capital A. Next. Slide, please, slide 20. Chair, it must be emphasized that IPID's mandate in terms of Section 2066 of the Constitution extends only over the SAPS and the MPS and not to other law enforcement agencies. Then clause 17 deals with reporting obligations and cooperation by members. Amendments proposed to Section 29 of the Principal Act impose the reporting obligations in relation to matters for investigation by IPID in terms of Section 28. Included are the municipal manager and the executive head of municipal police service or any other member of a municipal police service. Clause 18 deals with disciplinary recommendations. Chair, this clause seeks to amend Section 30 of the Principal Act in order to strengthen the provisions relating to the implementation of disciplinary recommendations of IPID, as well as to specify whether the disciplinary recommendations of IPID were implemented and the extent of the implementation thereof. In the published version of the bill, it was provided that SAPS or the MPS must initiate disciplinary proceedings after the investigation of allegations has been finalized by the Directorate and upon receipt of an investigation report. Slide 21, this is continued. A comment raised in the public comments was that this proposed amendment is undesirable. It has a potential to do great harm by curtailing police management from initiating disciplinary steps or precautionary measures against or taking precautionary measures against police officers with prima facie evidence of egregious criminality against them, thereby enabling such officers to remain on duty pending the outcome of an IPID investigation. Provision has also been made for the disciplinary proceedings to be a parallel process so that there are no unnecessary delays in the outcome. Therefore, the process so that they are, okay, that's just a repetition. Therefore, the word must was replaced with may in order to afford SAPS and the MPS management an opportunity to exercise a discretion as to whether or not to suspend the initiation of disciplinary proceedings. There are sufficient checks and balances, Chair, to ensure that SAPS is indeed following the recommendation of IPID, such as reporting to the Minister, the Portfolio Committee, and to the Civilian Secretariat for Police Service, who can inquire on any irregularity with SAPS's outcomes of discipline process and the sanction. It must be noted that IPID's recommendations are remedial in nature and not binding. This is the same with the Public Protector, whose findings are not binding and may in some cases require definite rulings by a court to enforce the same. Slide 22, in order to address the proposal in the public comments that there should be clear consequences for failure to act on recommendations of IPID to ensure accountability, a new subsection has been inserted in which it is provided that where the sanction is considered not appropriate, the Directorate may request the appropriate authorities of SAPS and MPS to review such sanction. Clause 19 deals with the finances and accountability. It seeks to amend Section 31 to provide that IPID shall be accountable to Parliament and not only to the Minister. Clause 20 deals with offences and penalties. In order to further address the aforementioned proposal of consequences for failure to act on the recommendations of the Directorate and to ensure accountability, Section 33 of the Principal Act has been amended to slide 23, please, to provide that if the appropriate authorities of SAPS and MPS fail to comply with Section 30, they shall be guilty of an offence and liable to a fine or imprisonment for a period not exceeding 2 years. Chair, the latter sanction is in the hands of the court, as is the amount of the fine. This too is within the purview of the court, who is guided by the Adjustment of Fines Act. Therefore, to this exact sanction of imprisonment or the amount of the fine cannot be expressed in legislation other than that which I've stated, which is the Adjustment of Fines Act. So that is within the hands of the court and not for us, for the department to decide in legislation. Clause 21 deals with regulations, and the clause has further been amended in order to empower the Minister to make regulations in relation to a procedure to be followed in appointing investigators. This new insertion further strengthens the Principal Act. Chair, I mentioned earlier on the in terms of the torture and GBH matters that they will be now also handled in regulations on how that will be dealt with, so that they will be in line with the OPCAT obligations. Then clause 22 deals with savings, and this clause provides for a substitution of Section 35 of the Principal Act as the transitional arrangements provided therein have been fully implemented. The savings clause will ensure that the conditions of service, including remuneration and benefits payable to employees of IPID before slide 24, the commencement of these amendments to the Principal Act may not be less favorable upon the commencement of the Act. Slide 23 deals with the arrangements, and it provides for substitution of headings of certain sections of the Act. Clause 24 deals with the short title of commencement, and it provides for the determination of the date on which the Act shall come into operation by the President by means of proclamation in the Gazette. And Chair, this brings me to the end of my presentation with the recommendation that Portfolio Committee on Police considers the revised proposals of the bill. Thank you, Chair.
Thank you very much. DM, can we continue? Are you fine?
Yeah, I'm fine, Chair. We can proceed. Thank you so much. Thanks, Advocate and Secretary.
Thanks very much. Honorable Whitfield.
Thank you very much, Chairperson. Are we going to now ask questions and comment?
No. I wanted Nicolette to finalize her presentation so that we deal with them all at once.
No, thanks, Chair.
You'll be the first. Nicolette.
Thank you very much, Chairperson. Chair, just to go on where I left off, I think I'm gonna cover also what the Secretariat maybe have noted. Chair, so in clause 1, in terms of the definitions, the submission made by APCOF has been included in terms of the definition for institutional independence and also operational independence. Also, and Chair, the submission made by IPUSA in terms of the definition for program manager, in that it is a structural position, has also been amended. Chair and honourable members, in terms of clause 3 regarding the independence and impartiality, as I recall, it was Honourable Gericke who noted the fact that IPID should be strengthened, its independence should be strengthened to be fully independent. And as I recall, the example was made of JICS, the Judicial Inspectorate for Correctional Services, in that it is currently located under the Department of Correctional Services, receiving its budget from the department, which constrains to a point or to a certain degree the independence, and this has been raised significantly in the past as a concern. Chair, just to note that that Parliament recently processed the Correctional Services Amendment Bill, and also with this, in this process, the issue of OPCAT was also raised and considered by the Committee on Justice and Correctional Services. Chair, in terms of that, the committee resolved that because there is an act or proposed bill in the pipeline to separate JICS from the Department of Correctional Services, that any inclusion of OPCAT will be better suited in the JICS bill when it is tabled in Parliament, rather than to include it into the Correctional Services Amendment Bill or Act now. It's been enacted. Yeah, so they felt also that it is more suited in terms of a separate bill dealing with JICS specifically, and not included in the Correctional Services Act under the section dealing with the Judicial Inspectorate. Chair, to move on to clause 4 in terms of the appointment, remuneration and conditions of service of the Executive Director of the IPID. I will not be dealing with the proposed revisions as noted by the Secretariat. Chair, I'm going to focus on the options for the appointment process, and that has been raised by members to date. There's basically three options, Honourable Chair and Honourable members. The first is to basically go with the appointment process as proposed in the revised version of the bill to retain parliamentary approval and basically reincorporates the section as in the current Principal Act, where the minister will nominate the executive director to Parliament, and then Parliament will have Chair.
Okay. We lost you for some time. Continue.
Apologies. Chair, so three options for the appointment process of the executive director is that we retain the provision as per the Principal Act, in that the minister will nominate the appropriate person, and then Parliament will either accept or reject the nomination. However, members have raised concern that this provision does not allow for sufficient parliamentary involvement, and raised concern that the committee is merely used as a rubber stamp for the nomination by the Minister of Police. Chair, then the second option will be for the appointment to be made by an independent panel to interview candidates and then nominate a suitably qualified person to the minister, and then this nomination will come to Parliament for approval or rejection. Chair, this was the submission or proposal made in the original published version of the bill back in 2022 by the Secretariat for public comments. Thirdly, Chair and honourable members, it was noted in public submissions as well as by members that the appointment could be made through a fully parliamentary process, similar to that of the heads of Chapter 9 institutions. However, as the Secretariat indicated, that IPID is not listed as a state institution supporting constitutional democracy under Chapter 9 of the Constitution, and this will naturally lead to an amendment of the Constitution. Chair, honourable members, the other concerns raised and addressed by the Secretariat was the term of office, that it be specified to a specific date, which has been over term, which has been addressed by the Secretariat. Also, in terms of the remuneration of the ED, and then the filling of a vacancy where members raise concern that this time lapse may be a bit too long, that the 6-month period should be condensed to a certain degree. However, even in last week's meeting, the Deputy Minister explained that it is a quite involved process to appoint to publish for the nomination and applications, and then to actually appoint the person as executive director. As the Secretariat explained, in terms of clause 5, the proposal by the Institute for Security Studies was accepted in that section 7, sub 6, sub A and B will be now referring to recommendations instead of complaints, as the Directorate deals with recommendations or make disciplinary recommendations instead of complaints. So this has been effected. In terms of clause 7, public submissions raise concern that the IPID should not, or the IPID should identify and review its own legislation without the involvement of the Secretariat. But the Secretariat has explained this provision, and also to note that the Secretariat is responsible for the drafting of legislation in the police portfolio in consultation with the departments concerned. In terms of clause 12, the Secretariat also addressed this issue, where APCOF and others argued that the removal of the grade 12 certification or equivalent diploma or degree will have a negative effect on the IPIT, has been reinstated into the revised version. In terms of clause 13, the remuneration and conditions of service of investigators, the Secretariat has raised this in terms of the creation of a precedent where the minister will determine salaries, etc. However, as the Secretariat stated, the IPIT investigators are appointed in terms of the Principal Act and not the Public Service Act, and therefore they have a different compensation dispensation. In terms of clause 14, the submission by the Institute for Security Studies has been accepted, and as a result, clause or section 24 sub 5 has been removed from the revised version. And then the new section 24.6 also includes when a person is not cooperative. In terms of clause 16 on wheelchair and honorable members, this one revises section 28 of the Principal Act. This clause has gathered significant public comments in terms of the removal of IPIT's obligation to investigate all cases of assault, limiting investigations to only assault with the intent to cause grievous bodily harm. Second, limiting IPIT's obligation to investigate all cases of the discharge of an official firearm to cases where the discharge led to attempted murder. Chair, also a submission raised concern about where custody starts, but there is quite a clear distinction between custody, arrest, and detention. The Secretariat addressed the issue of death of persons, not only by police action, but also by omission. The suggested revisions to section 28C, 28 sub 1C, is basically to align section 28 with section 49 of the Criminal Procedures Act, and to focus only on instances where a police officer has exceeded the bounds of reasonable use of force and thus attempted murder. And just consideration should be given to the submission by Gun Free South Africa that when a firearm is fired, there is a reasonable chance that someone will be killed either by a stray bullet or shot during arrest. Honorable members, the public submission noted in terms of the use of a firearm should in fact also include all forms of less lethal instruments, including like tear gas, rubber bullets, tasers, and stun guns. and this has been effected in the revised vision. The concerns raised on the limitation of investigation of assault only to include GBH and not all common assault cases. Also raised quite a number of concerns, and I have think through yesterday an article written by two of our public submissions and the presenters, David Bruce from the ISS and Daniel Knutze from Viewfinder, in which they made a strong case for the in agreement that minor cases of common assault should be excluded, as this really overwhelms the workload of IPIT. As Secretariat indicated, the case of torture is in line with the definitions of the Prevention and Combating of Torture of Persons Act of 2013, and then also the extension of IPIT's mandate to include law enforcement agencies and the private security industry is not within the scope of this bill, and the expansion will definitely encroach on the functions and powers of municipalities in terms of the Constitution, and also private security officers do not constitute members of the SAPS or municipal police service as defined in the SAPS Act. And three honorable members, this just shows the revised version of 28 sub 1 sub G capital A in terms of the use of any weapon or instrument. In terms of clause 18, consideration has been given to legislate for the mandate of IPIT or IPIT to actually compel the SAPS and municipal police service to review cases where it is found that sanctions of the disciplinary inquiry has been too lenient. And this has been included or given thought to. And then this whole issue that was explained about must and may, where the IPIT does have a discretionary power to investigate or start investigations in terms of the SAPS and vice versa. Honorable Chair and members, in this clause, there are some considerations to be given, either to strengthen IPIT's power to compel the SAPS and municipal police service to implement recommendations made by the IPIT and thereby remove the veto power of the SAPS and municipal police service not to implement recommendations. Secondly, we can legislate for more involvement of the IPIT in disciplinary processes and disciplinary procedures, but this will also necessitate a review of the SAPS disciplinary regulations. There was also a comment made by members in last week's meeting that the MPA should be compelled to report in more detail on decisions taken not to prosecute cases referred to it by the IPIT for criminal prosecution, and this should include a legislated reporting line between the NPA, the IPIT, and the Minister of Police. In terms of clause 20, offences and penalties, that's a new clause that was inserted. The section was not originally included in the original version of the Act or the amendment bill. Apologies. And it basically strengthens the specific section in terms of consequences for failure to act on the recommendations of the Directorate to ensure accountability. And this might address the concerns raised in terms of Section 33 or mentioned above in this one by the Section 30. During public submissions and concerns raised by members, there should be an inclusion in Section 33 sub 6 to have the amount of the fine issued for failing to comply with Section 30 of the Act should be quantified. However, as just explained by the Secretariat, this comment should be noted as the fine is determined by the courts and cannot be legislated in a specific bill. And then clause 31, in terms of the regulations, it's just a new subsection to empower the minister to make regulations in relation to procedures to be followed in appointing investigators. Chairperson, honorable members, thank you. That concludes my section.
Thank you very much. Can we, honorable members, interact with the presentations from both Secretariat and our content advisor? As I said, I'll start with Honorable Whitfield. Honorable Whitfield.
Thank you very much, Chairperson. And allow me to begin by saying thank you to all of the presenters for the extraordinary effort that has been put into synthesizing the public comments, identifying areas for compromise and concession in the interests of strengthening IPID's functions, in particular IPID's independence and effectiveness in executing its mandate. Chair, I also would like to begin by saying that I have been convinced by the arguments around OPCAT. I believe that there is more overarching legislation where the OPCAT could be situated, and it would then be the duty of this committee in the 7th Parliament to ensure that it engages with the relevant committees involved to make sure that the OPCAT finds expression in our legislative framework. Chair, I would like to just begin also by saying that at the introduction of this bill, there was tremendous concern around the constitutionality of the bill, which was borne out in multiple legal opinions. There was unanimity and consensus in this committee that the bill which was introduced was unconstitutional. The committee decided to proceed and voted on a motion of desirability, which was agreed to by the majority of members, and it was brought through this process to where we are today. At one of the original meetings when we were discussing the bill, I asked the question to the Civilian Secretariat and didn't receive an explicit response. And the question was whether the Civilian Secretariat for Police had advised the minister. And this was a question directed to the Civilian Secretariat, not to the Deputy Minister or the Minister, but to the Civilian Secretariat. The question was whether the Minister was advised by the Secretariat that the bill would be unconstitutional in the format which it was introduced. And I think that that is an important question that still needs to be answered while we deliberate on whether this committee is going to sign off on the amendment bill. And the reason I say that is because when we legislate, we must always legislate for the worst amongst us, not the best amongst us, and for a future possibility of enhanced political interference in the operations of independent body. And so understanding whether that advice was given or not is instructive to how the committee specifically deals with ministerial powers around the appointment. Because if the advice was given and ignored,
it exposes a rather sinister intention, which would have been, and perhaps still is, to cut Parliament out of the process. Now, while Parliament's function has been restored as per the existing Act, that is fine. But as I've made the point before, it is not satisfactory. And it is not satisfactory because Parliament was used as a rubber stamp in the past, and we have a duty to ensure that we strengthen the independence of IPID. Now, in the presentation today from the Civilian Secretariat, Advocate Bell offered an opinion. And her opinion was that my proposal for an enhanced role for the committee in the appointment process of the ED would lead to delays. I would hasten to say that the intention there was that it would lead to inevitable delays, that the committee would slow down the process. And I would like to remind the Civilian Secretariat and all members of the committee, and if I'm not mistaken, only 3 or 4 of us have been on this committee since 2019, that when the current Executive Director of IPID was appointed, she was not appointed within the legislated timeframe. It was the minister who was in breach of the Act at that time. And so the opinion, or the argument, that somehow, if the committee played a greater role, it would slow down the process of appointment, cannot be considered valid against that backdrop. And I want to be very, very clear in reiterating this point, because the Speaker of Parliament was clear at the time. When the Speaker of Parliament responded to the Minister's request for extension to the nomination process, she stated that in reference to Section 6, subsection 5 of the Act, that, and I quote in her letter, which served before this committee, I quote, "The wording of this particular provision is very specific and does not allow for any extension to be granted even by Parliament." The Speaker went further to say, and I quote, that the vacancy remains unfilled since becoming vacant in February 2019, on the face of it, is a breach of Act. So I want to dispel the myth that somehow Parliament becoming more involved in a process which is replicated across other institutions of the state, not just Chapter 9 institutions, but other bodies. There's an involved process for Parliament to play increased oversight in the appointment process, that the myth that the committee will somehow slow that down is invalid. And it's invalidated by the fact that even with a full year to appoint an executive director, the very minister who's supposed to shorten that process, according to the Civilian Secretariat, failed in his duties. So now that that is out of the way, Chair, I stand by my proposal, and I believe that in Nicolette's incredible report, the 3 options around this, number 2 remains the favored option. And not just because the minister missed his deadline, but also because it remains unclear what the minister's intention was to send an unconstitutional bill that cut out Parliament's role in the process. And that speaks volumes for how Parliament will be treated when it is sent a nominee in future. Chairperson, there were a number of inclusions from the public participation process that I want to just acknowledge without citing them, but to commend the drafters for incorporating as many as possible. I think there's a lot of room for improvement insofar as strengthening IPID's functions from an oversight point of view within the self-disciplinary process. But I also want to make the following point. I have twice made the point about the SAP's disciplinary regulations, Chair, and you can see it in the drafting of the bill that it should really have been done in concurrence with the drafting or the review of SAP's disciplinary regulations to make sure that there is alignment. And I would really appeal to the committee to find consensus on requesting the Civilian Secretariat to provide us with a briefing, a detailed briefing on precisely where they are in that process, what the intentions are surrounding the review, how the review of the SAP's disciplinary regulations have been considered in line with the IPID amendment bill. If the two are being done in complete isolation, well, then we're going to have more and more problems down the line, because SAPs will simply turn around and say, well, our regulations contradict the Act, and therefore this can't be done and that can't be done. And so I think we must just be conscious of the fact that aligning the SAP's review, the review of SAP's disciplinary regulations, is absolutely fundamental to giving full expression to the amendments that we seek to make in the bill. And so that is just some context, Chair, but also a request. We receive a report, a presentation, so that the committee can satisfy itself that it is not being led into an isolation chamber that is separate from the review of SAP's disciplinary regulations, where we may find ourselves passing legislation which remains in conflict with SAP's own internal processes. Thank you, Chair.
Thank you, Honorable Fortfeld, for your comprehensive input. Honorable Peacock.
Thank you, Chairperson. Let me appreciate the presentation made, and let me take this opportunity to have an input on the presentation made, Chairperson. My point will be mostly on the OPCAT proposals as well as the appointment of the Executive Directorate. IPID Amendment Bill is to provide for the Directorate institutional and operational independence of the SAPS and to enable it to exercise its powers, functions without fear, favor or prejudice or any undue influence, Chairperson. Now, to give the effect to the judgment of the Constitutional Court in the case of McBride versus the Minister. Furthermore, the bill seeks to provide for a more open and transparent process for the appointment of the Executive Director of IPID. Looking at the bill or the amendment bill, Chairperson, this subject is covered sufficiently, and as an all aspects as it given by the IPID required independence are covered within the bill. Now, Chairperson, my proposal is to include OPCAT is not supported at all. It is clearly outside the subject of the bill, and it should be noted that the obligation of implement of OPCAT is not limited to IPID, but an extent to other institutions as mentioned on the presentation, Chairperson. It is therefore only logical that the legal provision of regulating OPCAT should be inclusive in one piece of legislation and not be dealt with in different legislation. As I was listening to the presentation, Chairperson, and having looked at the document sent to us, Chairperson, I'm just emphasizing on what has been presented. I'm also in support of what is being presented. In conclusion of the OPCAT obligation in IPID bill will be limiting as other rule players are not subjected to the IPID Act. So, Chairperson, as you can hear from what I'm presenting here, is that I'm referring to what is presented and that I'm in support. And Chairperson, the non-inclusion of the OPCAT obligation in the IPID bill does not in any way prejudice the implementation of the protocol, as IPID is already implementing the protocol. All the submission that proposed the inclusion of the OPCAT in the bill did not propose any new responsibilities beyond. So what is currently on the case, which then implies that nothing will be missed.
to provide for the inclusion coverage of the OPCAT obligation for all institutions which are part of the national preventative mechanism. In my view, we support the proposal to include the OPCAT obligation in either the Prevention and Combat of Torture of Persons or Persons Act of 2013. Alternatively, a new bill should be considered in this regard. So, Chairperson, that is my proposal towards the proposal for the OPCAT. Now, when it comes to the appointment of the Executive Directorate Chairperson, the revised bill clearly provides for the oversight role of Parliament in the appointment of the Executive Director. The retention of Section C as stated, Section 6 as stated, subsection 1 and 2 of the IPIT Act in the bill guarantees that Parliament, through the portfolio, will exercise its oversight powers in the appointment of the AD. We should at all times not forget that the IPIT is not a Chapter 9, as already also instated or stated in the presentation given. That is not a Chapter 9 institution, but a government department which falls within the executive branch of state. We therefore cannot take over the executive powers, as this will be totally against the doctrine of separation of powers. With regard to Section 6, subsection 1 of the IPIT Act, it provides for the minister to nominate the candidate for the executive director position in accordance with the determined procedures. As presented to us by the department, the procedure includes interviews of the candidates by the panel set up for this purpose. And it is therefore clear that minister does not wholeheartedly or willy-nilly come up with the name. So the revised provisions for the appointment of the executive director in the bill are supported as stated, Chairperson. So from my side, this is what I've done, and that is what I submit to you for the committee to deliberate or to look into. I thank you, Chairperson.
Thanks very much, Honorable Peacock. Honorable Gerike.
Thank you very much indeed, Chairperson. And let me also express gratitude, appreciation, and respect to the officials for thorough work and research put into the specific bill. It is quality work that served before us this morning, Chairperson, and we must show some level of appreciation. Let me start. I have a number of issues here, but let me just start with the OPCAT. I agree with the first speaker. I think it's Honorable Whitfield, if I understand it correctly, that the issues and the questions raised the last time around OPCAT have now been answered, and that was the position of the EFF in the first place, that we also need to have need to support a multidisciplinary approach in this regard. But it is important for this committee to say that we do not reject, refute, or negate the inclusion of the principles of OPCAT or the obligations of OPCAT, but that we somehow, I don't know how we're going to do it, but write in some line or paragraph to say we are in favor of OPCAT, but not for the inclusion into this bill. But therefore, it automatically will bring put the obligation on this committee to champion the inclusion of OPCAT, even when we align all other relevant committees or authorities or institutions to be in alignment with OPCAT. I think it's important to understand that and also to make a note about this, even if it's in the preamble of the bill. So we are satisfied with that, with the multidisciplinary approach, because you cannot have a piecemeal approach, but you must have a comprehensive approach. Secondly, Chair, I also had after the last engagement of the committee, I went to do some research on the issue of the appointment of the executive director, and I came across a different type of or formulated a different type of view in this regard, saying that yes, we stick to the initial articulation that the executive director, that those powers should not be taken away from the minister. The constitutionality of this may be debated, but in terms of the Constitution Act of South Africa, if you go and look, if you look at Section 97, 98, and even 99 of the Constitution Act of South Africa, you will note there that the Constitution speaks about the transfer of functions. 97, 98 speaks about the temporary assignment of functions. And 99 will tell you the assignment of functions that may also be affected by even ministers. So the Constitution, there is a constitutional provision for the president to assign that powers to the minister, and the minister may act accordingly in terms of the powers assigned to him by the president. We must understand in terms of doctrine of separation of powers, and I'm very strong on this, because this is where most of the things fall flat in the courts of law, because people don't understand the separation of powers in many ways. The president is appointed by parliament. The minister is an extension of parliament by virtue of the fact that he's been appointed by the president. That is so. It's not non-debatable. So when you say that the minister may appoint or must appoint the executive director, you're giving the minister direct powers, and it should be like that. Because you cannot have a lame duck. You cannot have an executive position and you have lame people in that position, weak people without power, just with a title but no authority. So therefore we must give authority to the office bearers, whether it be ministers or DGs or whoever, so that they act within that authority. It's a very important point in our constitutional democracy, because other than in the old apartheid days that you still have to go back, you cannot make a decision because you must still go back to the boss or to the supervisor or whoever. The authority or the functions or the delegations are now enacted, and therefore a person can act within that authority. It is important, very important to understand this. So that point, it's clear for us as the EFF. I'm satisfied with that the minister proceeds to appoint the executive director, subjected to the fact that the minister has got a committee that will do some recommendations and so on and so on and so on. Chair, I am still not, convinced about and in inverted commas, the independence. I think the independence of IPID needs further interrogation, deliberation, or investigation, some sort or another, because I heard somebody said that IPID is a government department. Now, if you say that IPID is a government department, it will not stand constitutional scrutiny, even in the Constitutional Court. Because if you say it's a government department, but you talk about independence on the other side, obviously there's problems awaiting us in front if anybody takes this up. And therefore we must maybe think out of the box to describe or to in the foreword of the bill come up with some other definition, or that will lead us to some kind of understanding of independence, that IPID is independent. I don't know if I do express myself correctly in English, but this is the understanding. You cannot say government department. If you say government department, then IPID is directly linked to government. This may have some other outflows or results for that matter, because even though you say IPID is independent, but if there are other problems, for instance, like disciplinary procedures and so on, IPID must be subjected to government procedures and to the relevant legislation. it doesn't make sense. It doesn't make sense, Mr. Chairperson. So if we can just further, deliberate or get some opinions on that, then I think we may be on the right track. Then on the issue of common assault is the second last point. Still not totally convinced, because common assault is a major issue, and although the person may not obtain wounds or wounds being inflicted or what have you, in that definition per se, that person will still be assaulted. Now, you can say, we can talk about minimum force by the police and so on, but then again, we must take into consideration the Constitution Act, Bill of Rights of every individual of this country, every individual, so to speak. But further to that, Mr. Chair, is the fact that looking into the future, for now we concentrate on the police and on the municipal, what did you say, MPS, Municipal Police Service. It's the only two components that we concentrate on at the moment. But you know what is happening now with some municipalities is that they employ law enforcement departments, and they ascribe or assign certain powers to those law enforcement departments, and they apprehend people, they chase people on the streets around, they, and in many instances, they make themselves guilty of some kind of assault or what have you on some certain individuals. So in future, and I think very soon, we must look at including law enforcement divisions of municipalities as well, because they have got to do with law enforcement. The same principle applies to, you will notice that in the country, in the entire country at the moment, there are bodies or, I don't know, bodies or institutions or what have you, that try to assume the role and responsibilities of the police, and they call themselves neighborhood watchers. Now, there is a definition for neighborhood watchers, but some of these neighborhood watchers, they overindulge in that field, and they try really to assume the roles and responsibilities of police. So in many instances, CPFs as well, because they take part in patrols and so on. So I just thought maybe the bill should expand, maybe not in this term or maybe not in the near future, but the bill, we should wrap our minds around the fact that we say the bill should include all organizations and individuals, even security organizations, companies that are responsible for the application of law and order on our streets. Because there is just an abuse of power, and there's no recourse for these people, because in many instances, some of these guys, particularly in small towns, they are linked to the investigating officers, and these cases are, in most instances, brushed under the carpets. We have to look comprehensively at this all, Mr. Chair, so that we bring about a better life for our people. Thank you very much indeed.
Thanks very much, Honorable Gerike. Honorable Peacock, if you can lower your hand, unless if you want to come back later. Honorable Golding.
Thank you very much, Chairperson, for the opportunity. Firstly, I would really like to thank Advocate Bell for the presentation, and of course, Nicolette, for the detail which you've gone through. It does really help us in this process to understand and comprehend all those comments which we received from the public. It was quite a bit, and it was replication. So having it put in a very succinct format has really helped. Firstly, Chair, I would like to reinforce Honourable Whitfield's comment as it pertains to the appointment process and oversight. If you've looked at his comments, which he sent through previously, which I've looked at now, there are two sides. There are two things which our focus is. The first side is that we legislate, but let's not minimize our oversight function. I'm sure there's a compromise which can be worked out at that level, but I do think we'll be looking at in a bit more detail. I I then do want to just touch on this issue of OPCAT. I do agree that it does seem to make sense that it is centralized. Based on that, I will remind you of the request, which I think that the DM put out earlier on, was that we do arrange a meet or a sit down with the other PCs who are involved to thresh this out, to understand specifically where it sits. Because I do understand that the application of this is a lot broader than just SAPS or policing. But if we can put that on our action list so it doesn't just disappear. But thank you for that. Before I get to the one point I really want to make, I just want to touch on the last point made by the Honourable Gericke, as it pertains to the government institution or department. I do think where this is heading ultimately is for it not to be termed such. It would need to be a Chapter 9 institution. That's not in our purview now, but I do think it's one of those things which would need to blip on our radar, and we would need to understand what that institution looks like. Then I would like to thank Nicolette. There was commentary made about the inclusion of law enforcement members. I have touched on this previously. Nicolette, thank you for the legal opinion which you sent through to me. I've gone through it in detail, and this is a bit of a minefield because it doesn't just cover law enforcement services, but would probably cover broader fields such as SIRA and the Road Traffic Management Corporation. Let's not forget that the first line in this would be SAPS, and those complaints and charges would be laid there. When comment was made with regards to the minister creating a selection committee or panel, that was purely indicated as best practice and happens. And I believe Advocate Bell's words were, the minister may, and the word is may, constitute a panel. I just think we need to understand what that process is. We should lay it legislatively exactly what that process is. There shouldn't be any if, buts, or maybes. But let me get to my primary point. It has to do, and I'm taking guidance and feedback from Mr. Daniel Kutzer and David Bruce in terms of their presentations. And Nicola, thank you for the article which you sent out. It pertains to, I think it is clause 16, section 28 of the Principal Act as amended. And as things currently stand, it says the Directorate must investigate. And the issue touched on here was assault common versus assault GBH. Now, currently it says assault must be investigated. And that is putting a heavy burden on IPID. I see that we did bring that change in as recommended, and the change was the may and must as it pertained to the instituting of disciplinary action within SAPS. Part of the recommendations made by Mr. Kutzer at that point pertain to this as well as it pertains to assault. So I think we need to look at it in terms of the wording. My gut feel is that with assault GBH, it must be investigated. But in the cases of common assault, we may well give IPID a bit of flexibility here. And in this case, I think we should separate it. And the wording should be may. An investigation will happen by SAPS in any case. As I indicated in the in-person session, was that case docket could be referred to IPID from SAPS. And in that case, IPID may take that investigation further, or it may not. And I think this is where we help IPID a bit and give them a bit of flexibility when we separate those two out. And in the one case, it stays as must. And the other case, I think it needs to be may. And I think that may well give them a little bit more discretion at the IPID level and ease up their workload. But thank you, Chair. That is all. And I look forward to the clause walkthrough. Thank you very much.
Thank you very much, Honorable Golding. Honorable Molekwa.
Thank you very much, Chairperson. Let me also start by appreciating the presentation and also the submission of proposal made or submitted towards the amendment bill. But Chairperson, I think the proposal to include the OPCAT in the IPID amendment bill is not coming with broadening the scope of the work that is already performed by different stakeholders in the OPCAT. Or neither is identified to improve the implementation of the project. Instead, Chairperson, it seems to be focused on ensuring that OPCAT is in the legislation, even though in this case it will be limiting, as it will be covering the role players and leaving out all the role players in the NPM. This is undesirable and therefore should not be supported. More so, it will also derail the process that is already at that advanced stage. Like all other role players in the NPM, IPID should continue to play its role as it relates the OPCAT obligation. Chairperson, it should be emphasized also that the non-inclusion of the OPCAT obligation in the IPID bill does not in any way prejudice the implementation of the protocol as IPID and everyone else is already implementing the protocol and reporting on it on regular basis as required by the bill. And also, Chairperson, I want also to comment on the appointment of the Executive Director. That, Chairperson, it is important for the committee to respect the fact that the IPID is a government department and not a Chapter 9 institution. It is therefore out of question to consider taking the responsibility to run the recruitment process for the responsibility, to run the recruitment process for the Executive Director. The Popular Committee cannot be burdened with administrative function that is correctly assigned to the Executive. Secondly, Chairperson, the committee cannot be both the player and the referee at the same time. The role of the committee in the appointment should be limited to the oversight function. This is sufficient covered in the revised bill, and therefore the bill is fully supported. And the provision to limit the recruitment process to 6 months is also welcome, as it will ensure that the position does not remain vacant for too long. But at the same time, Chairperson, providing enough time for the position to be filled. So, Chairperson, I think that is my submission with regard to the amendment bill. Thank you very much, Chairperson.
Thank you very much, Honorable Molekwa. Honorable Gomba. Honorable Gomba.
So sorry, Chair, I forgot to unmute myself. My apologies. Honorable Chair, greetings to the members of the Portfolio Committee, Honorable Chair, and let me welcome the presentation, Honorable Chair. Honorable Chair, I would like to be very short since my gadget is about to switch off due to battery power. But Honorable Chair, I want to actually advise the committee we need to guard against the introduction of provisions in the bill that have unintended potential of limiting the oversight functions of the other NPM members. It is strongly supported that OPCAT should be included in the common legislation, like the prevention and combating of torture and of Persons Act of 2013, Act number 13 of 2013. That way, Honorable Chair and members, all the role players will be guided by the same legislation as opposed to each one having a different legislation, Honorable Chair. Coming to the appointment of the Executive Director, Honorable Chair, from the onset was an acknowledgement of the need to fix the challenges with Clause 4 of the bill to ensure oversight role of the Parliament in the appointment of Executive Director. Honorable Chair, that has been indeed done through the retention of Section 6.1 and 6.2 of the Principal Act. It should be noted that both sections did not have challenges and were not subject to the disputes that went to the Constitutional Court. It is therefore, Honorable Chair, clear that their retention is sufficient and in dealing with the constitutional challenge that existed before the bill was revised. Clause 4 of the introductions on Clause 4 further introduces provisions that enhances that appointment of the ED. This includes the requirement of persons must meet before he or she can be regarded for appointment, and also the period that the ED can be appointed for which regarded the appointment, and also the period that the ED can be appointed for, which limits to 7, similar to that of the head of the DPCI, the Hawks, in other words, or the public protector. Thank you, Honorable Chair, and I'll pause there.
Thank you very much, Honorable Gomba. Honorable Marekwa.
Thank you, Chairperson, and good morning to yourself, the DM members, honorable members on the platform, and all participants who are present on the platform. I note also the ED from Pete. Thank you, Chair. Let me, without any waste of time, welcome and also join the colleagues in expressing my appreciation for all the presentations for today. Chair, under OPCAT, my input, Chair, will be, one notes that through government processes, we know that IPIT and other bodies like your South African Human Rights Commission, they are members or parties to the National Preventative Mechanism, the NPM. There are other parties also members to the NPM. And it will be known, Chairperson, that once you become a party to a body like the NPM that has been established, it will be required for those parties, Chair, to be to develop or establish systems that allows them to conduct regular visits to places where people are deprived of their liberty, or in order to prevent torture and other cruel or inhuman degrading treatment, even punishment. And when we talk about these places, what comes to one's mind is issues like police cells and other areas where people are being held in. And then also, Chair, as parties, it will be those parties that I've mentioned, your IPIT and Human Rights Commission. It will become a known fact that there will be also binding agreements that will be put in place, because you can't have a body where people are affiliating and there are no agreements or rules. But there will be binding agreements that will be put in place, and then that will allow or enable the members including IPIT, to carry out their OCPET obligations and report on those to that particular body. IPET, as far as one is concerned, is that it is accordingly carrying out its obligations in this regard, in this regard, and that is no dispute regarding that. This then confirms that there is the non-inclusion of the OPCAT in the bill will not or does not affect its implementation. Clause 16, subsection 1, 9F of the bill, Chairperson, provides for the investigation of complaints of torture in terms of the Prevention and Combating of Torture of Persons Act of 2013, number 13, as well as assault GBH by members of SAPS or MPS, as it was prescribed with also in the bill. This provides an opportunity for how to express OPCAT obligations in the IPIT regulations to give effect to the protocol. Chairperson, in view of this, it is clear that there is no need to include an OPCAT obligation in the bill, but to give serious consideration that be taken to include it in the inclusive bill that will be set as a standard for all role players in the NPM. Chair, as I go towards my conclusion, the issue around the appointment of the director, executive director, I want to say that the independence of IPIT as required by Section 206 of the Constitution of our country, South Africa, and further it's further emphasized in the Constitutional Court judgment, does not entail taking over the role of the executive. I think that we need to note. And as it relates to appointment of the executive director, the different branches of the state are required to work together from time to time in harmony with each other, carrying out its legislative mandate. The revised bill, Chair, provides for the clear distinction of the role of the executive and the role of Parliament in the appointment of the executive director. It should not be the intention of this committee to vilify the executive, but instead the committee should aim at providing the oversight over the executive. Clause 4 of the revised bill is supported as it provides enough safeguards in the appointment of the ED, which is the executive director for IPIT. Parliament will have enough opportunity to comment and express its views, Chair, on the nominated candidate when the minister submits the name to Parliament for confirmation. It is therefore not necessary to infringe on the functions of the executive under the pretext of exercising caution, as it might be tempted in some areas to say that we are being cautious, but it should not also, we should remember not to encroach or infringe on the functions of the executive as much as a committee will be conducting oversight. Thank you, Chairperson.
Thank you, Honorable Marekwa. Honorable Majosi. Honorable Majosi.
Thank you, Chair. I have greeted before, but now that we are on this, I will just go straight to what we are discussing now, and do raise that, yes, there were concerns that were raised about the lack of parliamentary oversight over the processes for appointment of the executive director. And Section 6 of the Principal Act has been amended. The result is that subsection 1 and 2, which provide for confirmation of the appointment of the executive director by the relevant parliamentary committee, have been retained as such, which then leaves a lot to be desired, because then If we are saying Parliament must not be a player and a referee, are we not also referring that, which means the IPID won't be independent, because now, which means the minister will also be the player and a referee at the same time. And now it loses its authenticity of then being an independent institute. Section 22 has been amended to address the concerns in the public comments that the deletion of qualifications requirement of IPID investigators shall have the effect of juniorizing the level of entry for investigators. As a result, a person to be appointed as an investigator must at least have a grade 12 or equivalent qualification. Also, Chairperson, that we also raised the concerns that were raised in the public comments regarding the deletion of provision for investigations of complaints of assault, and also there were proposals that were made to retain the investigation of assault complaints by IPID, and also not only in assault and abuse, not only is assault and abuse of power, but the distinction between assault common and assault with intent to cause grievous bodily harm is often subject and not based on visible injury. It was not accepted, as most common assault cases arise from a scuffle during the arrest, and in some cases it is clear there is no evidence of physical assault. But I was happy when the DM said maybe we must have a meeting also with other portfolio committees that are included here, so that we get the proper maybe in alignment as well, to say what is it that we are agreeing upon, and also the legal opinion and whether the bill required further amendments to include provision that give effect to the optional protocol to the Convention Against Torture and Other Cruel, Inhuman and Degrading Treatment or Punishment. Public submissions proposed amendments to extend the National Prevention Mechanism mandate under the OPCAT, and that the mandate of IPID should be extended to include the capacity to undertake preventative monitoring of all places of deprivation of liberty. And as we know that currently, they even presented on our previous meeting that their footprint has not been able to reach everyone, and it leaves a certain concern, then, Chairperson, that if IPID cannot be able to go and reach everyone, then that also causes a serious problem. But also, Chair, I will no longer go clause by clause, because I'm not sure if on the table that was presented to us, are we still going to do the clause by clause, or we are doing it now? But I was raising those concerns, Chairperson, and you will tell me if maybe I would have to then do a clause by clause. But the appointment of an executive director, there should be a selection panel that makes recommendations to the minister of suitable candidates. Parliament must have authority to approve or reject decision of minister, which is based on panel recommendations, because to leave it all to the minister to do all the checks and balances, then it takes away the independence. This is a good check and balance on possible abuse of power, and also the selection panel must be formalized and place an extra administrative OPCAT will then maybe become a part of IPIT responsibilities. IPIT must not then be overburdened with work maybe that would be able to be shifted elsewhere so that they focus on their mandate. And also it must not be given extra capacity to deal with an increase of workload. Must be given a certain amount of flexibility and discretion in the matters it investigates to be able to prioritize and dedicate resources in pursuit of its objectives and mandates. And then, yes, Chairperson, I present that, and you will then direct me if you want me to go to all the clauses, because I saw when they were presenting our what do we call it? Our staff, that this is the table that they've presented, and we are still going to go through clause by clause, and they were presenting dates. I'm not sure if maybe we adopted that or we left it at that, so that then a person can go on clause by clause. Thanks, Chair.
Thank you, Honorable Majosi. Just to deal with your question immediately, we're going to have time to deal with clause by clause. Not today. I think it's next week, if I'm not mistaken. I think next week we have a meeting on Wednesday and Friday, but in one of those meetings, we'll deal with clause by clause. Today, we are making inputs so that when we move forward, the Secretariat is able to respond and see how some of the inputs can be incorporated. If not, give reasons so that we're able to move forward. I think all members have said their worth. I'm not sure whether Secretariat, DM, Secretariat, you want to respond to some of the issues?
No, thanks, Chair. I will ask the Secretary to come in, and then I'll come after him through you, Chairs. Secretary.
Thanks, DM. Thanks, Honorable Chairperson. There are a lot of comments that were given that will not necessarily need us to respond directly to, but we will respond to some of the questions that need direct response. Maybe starting with, I will deal with some, and then I will hand over to Advocate Bell for maybe more technical questions that I might not have. The first one that I want to respond to, the issue of the regulations, the review thereof. I think if we are required, we can present or submit a written response in terms of the regulations, where we will outline the steps that we have taken and the issues that we have identified that needs to be reviewed in the regulations. However, Chairperson, I want to emphasize that the concern that Honorable Whitfield raised at the end, to say there may be a challenge if maybe the current bill goes through, only to find that it's, using my own words, it is maybe contradictory to what the regulations is prescribing. So I want to indicate that there shouldn't be a challenge with that, because the regulation is a subordinate legislation, so it has to align to the legislation itself or to the act, and not vice versa. we want to, in terms of the comments made by Honorable Herike, I think we welcome and take note of. Though we missed, I think, the first one in terms of the OPCAT, we had a network challenge in the boardroom where we were connecting from. So, but otherwise, I think most of the issues that he raised were mainly comments that we take note of. Then, in terms of another question that was raised, I think it's Honorable Golding, and it was partly also covered by Honorable Majosi in terms of the process that is followed in terms of the appointment of the ED with regards to the appointment of the panel. Honorable Chairperson, I need to indicate that in clause 4, which is section 6, subsection 1, it has a provision that the procedure that must that is a procedure prescribed by the minister. So this makes a provision for the details to be included in the IPID regulations, as we cannot have all the steps described in the bill or the act itself. So, but in practice, what actually happens is a panel is appointed. Actually, it starts with the advertisement of the position once it becomes vacant, and then a panel, and that panel now assists minister in terms of the selection or the shortlisting. Then it goes on to do the interviews and then make a recommendation, which then will be processed, and finally it will reach the portfolio committee of parliament through the portfolio committee. The issue around the assault common and assault GBH, Chairperson, maybe one needs to indicate that the proposal where you can have must for GBH as the bill is proposing, and maybe for common assault. Yes, it makes sense. However, one needs to indicate that even if we don't bring that into the bill itself, this is still covered in terms of section 7, subsection 9H, which provides that IPID can investigate any other maybe referred, and it is also covered in terms of section 28. 1H in the principal act. So those are the issues that I thought maybe we can respond directly to, because most of the issues that were raised, I think, are issues that we have noted, and mainly I think the issues were revolving around OPCAT and the appointment of the executive director, and of course the issue that I've just addressed now in terms of assault. I think that would be our response, and thanks, Chairperson, and DM.
Thank you, Acting Secretary. DM.
No, thanks, Chairperson, and thanks to committee members for the constructive engagement that we have had, and once more also appreciating the input from the public and organized formations, labor, and other organizations that participated in these processes. It was quite enriching for one to go through what happened, and including the debate today, the responses from members, both from the DA, the EFF, and the ANC and IFP. Your input was quite enriching, and I think we have been able to come up with a beautiful piece of legislation that we can all be proud of. And we want to commend you, Chair, and the team for having steered the processes to where we are now. That is quite great. We can always do better if we focus on the objective and not look at other side issues that are not relevant to what we are here for. And I think yourself, Chairperson, together with your team, your members of the committee, and your support staff, legal advisor, content advisor, you have really steered the ship and assisted us greatly in this process. It was not easy. We all know the engagements that have been there, but you have risen to the occasion and provided leadership. And Advocate Bell and the acting secretary, Mr. Amaru, your persistence and patience have driven us so far. We really are grateful to you, and obviously we don't forget the role that the executive director and her legal team have played in this regard. It was not just a single person's effort. We all came to the party, and we are here today. And I think from the inputs here, it's very clear that all of us are able to associate with this piece of legislation as our product. And it's a product that will better serve our people better. I am really grateful, Chair. Thanks once more to your leadership and that of your committee, and the difficult questions that members of the committee have been asking us, and their insightfulness in these processes has enriched one. And I'm quite grateful to have been afforded this opportunity to be part of this team to do what we have been able to do. I know it is not the end, but I think it's appropriate that we must thank the committee and yourself, Chair, and your support staff for having driven us so far. We're quite grateful. Thank you very much.
Thank you, DM. Honorable Whitfield.
Thank you very much, Chair. I'll be very brief. I just, firstly, the Deputy Minister, it sounded like he was making the speech in the House that the bill had been approved. It certainly hasn't been approved, and I don't believe there is 100% consensus. So I think we just need to place that on the record, that the Deputy Minister's sentiments are very positive, but they don't reflect necessarily the views of individual committee members, and he certainly doesn't speak on our behalf, but I'm sure he knows that. Chair, I don't recall receiving a response to the very specific question, which was whether the Civilian Secretariat provided the advice to the Minister or to Cabinet or to any member of Cabinet that the bill in its original draft version, which was sent to Parliament, was in fact unconstitutional. And that may have been because it was a sound issue on my side when Mr. Romaru was speaking, but I don't have a record of that response. And I think it is absolutely instructive and fundamental to any further deliberations on the bill. Thank you.
Thank you, Honorable Whitfield. Now, the Deputy Minister is not saying we've approved the bill. He's saying the journey we've traveled up to so far, they are satisfied, and they even have hope that moving forward, we'll move in that spirit and come up with legislation that will satisfy the majority. There's no legislation that will satisfy everybody in the country, but it is our hope that it will satisfy the majority. But he knows that we are still continuing with the process as per the timelines. Yeah. Acting Secretary? I'm told the question is directed to... Oh, there's an echo there.
Yes.
Yes, Chair.
Okay, so we tried to resolve that as we are in the boardroom. But Honorable Chairperson, what I want to indicate is when we started working on the bill, when it came to Section 6 of the Principal Act. One of the challenges that was facing us, which we needed to resolve, was more of a balancing act, considering that you have the executive director as the head of a department, members spoke about earlier. And at the same time, there is a requirement for the independence. So when we worked on the bill, we tried, as I've already indicated, to have that balancing act. And it is for that reason that we had to go to other pieces of legislation that has similar requirement. It might not be exact, but similar requirement in terms of the independence. In this case, one reference point that we had, or one amongst many that we had, of the head of the DPCI, of the Hawks, then we sort of borrowing how it is worded, which will then imply that you are appointing a head of department, you satisfy the requirement of how heads of departments are appointed, but at the same time, you ensure that there is a role that Parliament has to play. Yes, indeed, the role that we had proposed at the time was not as it is in the report. We were dealing with this. We had to request the state chief state law advisors to advise us in terms of whether this will be constitutional or not. And when we were dealing with this matter, we had now to process the bill further before we could even receive the response from the Office of the Chief State Law Advisor. So by the time when we received this, we had already sent the bill through both to the minister, and after that process had been done and we received the opinion from the Chief State Law Advisor, it was then determined now in consultation with the minister or with the ministry that we need also have an independent opinion on the matter so that this matter can be clarified. And when we went to the council to seek this opinion, so the main question that we were asking was basically what I've already indicated, have this balance, because we are talking about a government, a department, wherein there are provisions in terms of how the appointment should be done, but at the same time, we have got a requirement in terms of the independence and making sure that we are in line with the McBride judgment. So that's basically the process that we had followed. So where we had to deal with that balancing act, rather balancing facts fired. So all the advices that we were giving was basically saying we are trying to have this balance between the executive director as the head of a government department, plus the executive director needing that independence. Hence, we had to look at the DPCI as an example. Thanks, Honorable Chairperson.
Thanks, Acting Secretary. Honorable Whitfield, I wouldn't want us to have a dialogue with you, but let me give you the last chance.
That's fine, Chairperson, but I think we need to understand how fundamentally important this is, and I don't subscribe to the explanation that was provided. And you know, if this is not the platform to debate the constitutionality, the process, etc., well, then perhaps we need to find other avenues in which to deal with it. But I do want to stress the point that the Civilian Secretariat, by their own admission, is responsible for drafting the legislation. Unless they sent a constitutionally compliant bill to cabinet, who then changed it, who then they only realized that, you know, this was unconstitutional after this chief state law, but it's something, it does not add up. And I simply do not accept the explanation which has been provided, that this was a balancing act. The entire genesis of that section and the contestation around that section emanates from a constitutional court judgment. And so the drafters of this legislation would have known that it required the approach that we are now dealing with, that the section as it is in the current act has now been restored in this version in the amendment bill. Chair, the point that I'm making is that it is impossible for drafters to not have known that the draft that they had submitted was unconstitutional. The question was whether there was any interaction with the Minister of Police surrounding the unconstitutionality of the bill at any point prior to its submission to Cabinet. And I mean, it's a pretty simple answer, but a very long explanation. It's either yes, advice was given that the bill was unconstitutional, or no. Based on the explanation, it sounds like the answer is no. If there's going to be no further discussion on this, Chair, it's fine. I will submit my views in writing and try to solicit a clear response in writing. I think that would be useful, and I would welcome the opportunity, obviously, for that offer that was made by the Secretary of Police to bring the report on the discipline regulations review to the committee. But thank you for the opportunity. I won't belabor the point any further.
Thank you very much. We'll close it at that. I see Honorable Gerike.
Yes, Chair, it's just very brief. As I'm new to this committee, but I need to understand certain things. I note that you said that that's the last point, but let me just understand: is the minister not an interested and affected party in this case, or to this legislation, or to this new bill? Interested and affected party, and if he is an interested and affected party, doesn't it mean that the minister has locus standi to also make a contribution to this bill? I'm just asking. Thank you.
Thank you very much, Honorable Gerike. The minister is an interested party, an affected party. Let me say, because I want to move towards closure, we will have, I think, the opportunity given by Secretariat to come and make a full presentation on their process of reviewing subdisciplinary regulations. As they come to present, they will also incorporate what Honorable Gerike has presented as a question, and what seemingly the Honorable Whitfield is not satisfied with the response. I think we'll have that opportunity to engage further in that regard. So what I'm saying is that as the resolution of this committee, I think members will confirm. This committee agrees that we are not extending the mandate of the bill to include OPCAT in this process. But like members have commented, there will be a way of including some of the objectives of OPCAT in the bill. And already we are told that there's provision in the legislation that the IPIT is already doing certain things. But what I want to hear clearly is that we're not extending the mandate, so that we agree that that is a resolution of the committee. Two, there will be a full presentation by the Secretariat on the review of the SAPS regulations. The acting secretary tried to brief us, but let's have a full briefing. And it's important because we're dealing with the amendment of the bill so that there's proper alignment. Three, we're agreeing that we must have a way of coordinating a meeting with other relevant PCs with a view to discuss how we go around the issue of OPCAT so that we don't do it in piecemeal, but we come up with something as recommended by the Deputy Minister. Am I correct on those resolutions? Honorable members, can you confirm or?
Yes, you're correct, Honorable Chair.
Yes, Chair.
Okay. Thanks very much. Those are the resolutions of this meeting. And DM, Acting Secretary, let's prepare that. Our administration will see how to slot time before we conclude, because we can't conclude the bill without getting that presentation on the alignment of disciplinary regulations, so that we know when we move forward that we are not leaving anything behind. And as you present or prepare your presentation, also talk to the question by Honorable Gerike that the minister is an interested and affected party. Therefore, the minister and cabinet might have views on any legislation before they present it to Parliament. So that procedure, and the Honorable Gerike indicated that he's still new in this regard. Most of us are new in this regard, and we want to be briefed so that we are on par with the rest. Having said that, Babalo or Nicolette, can you remind members of the program moving forward? What do we do on Friday? What do we do next week, Wednesday, and next week, Friday? At least up to next week, Friday. I know you'll still send that to members, but just remind them before we close.
Thank you, Honourable Chairperson. As a reminder, this coming Friday on the 10th, we'll have the clause-by-clause consideration on the bill. The next week, Wednesday, the 15th, we have consideration of the A list or the A version. And then the next week, 22nd of November, we'll adopt the bill in its entirety. But just on that, we might have a slight delay to accommodate the requested presentation from the Secretariat on the disciplinary regulations review, just to ensure that it is aligned. Chair and honourable members, so these timeframes might be slightly adjusted, but the parliamentary term has been extended by 1 week up until the 10th of December. We would have ended on the 1st of December. So we still have some room for maneuver to adjust the time frames too. Thank you, Chair. But we'll review the program of the committee and just slot that presentation on the disciplinary regulations as soon as possible. Thank you, Chair.
Okay. Maybe let me not put. I wanted to bring in Acting Secretary and Honorable Whitfield, but let me not do that. We will, as Nicolette says, we will see how to incorporate that presentation. Are we fine, members? You now know what you're going to do. Honorable Majosi, Friday is close by close. Are you fine?
Yes, I'm comfortable, Chairperson, close by close, Friday.
All right. Any other thing, members? Because I don't want us to be confused. Honorable Gerike, are you fine?
Chair, can I quickly just mention, I don't know where, I must still be guided, but there was a speaker earlier on that elaborated on the role of jigs and so on, as I have done also in the previous meeting. Let me just declare here that my wife is an employee of JIX. It's all I want to put on record. I don't want conflicting interest. You must rule me out whether I must be part of the next, whether it's going to be a broader meeting amongst parties and so on, but you must inform me in terms of the way forward, in terms of conflict of interest, Mr. Chair. I don't think so. I don't think there's a conflicting interest, but I just mention it out of respect for the committee. Thank you so much.
Thank you for mentioning that, but I think you are still on the right track. You are still fine.
Thank you, Chair.
But thanks for mentioning that. We'll always remember it whenever we discuss certain things. In this committee, we are not approving tenders. Thanks very much, Honorable Gerike. Honorable members, I'm closing the meeting. Earlier on, Honorable Meshwe apologized to leave early because he was not feeling well, and we missed his participation. We really want to wish him a speedy recovery because we want every member of this committee to be present as we discuss this important bill so that the views of your constituency are well represented here, as we are here representing the people of South Africa. Having said that, members, thanks very much for your contributions. Like we always say, we are in a meeting because we have different views and we want to express our different views so that ultimately we agree to agree or agree to disagree. But that has nothing to do with our personalities. So don't be afraid to present your view because you think it will not be taken. Present your view. That's why you are a member of this committee. But ultimately, the views of the majority of members of the committee will prevail. And don't feel undone because that's what democracy is all about. But I think Secretariat has taken note of your views. And when we come, there will be some improvements. In the main, members of Parliament are agreeing with the two presentations, but just to check up here and there so that we are able to move forward. Thanks very much, members. Enjoy the rest of your day. The meeting stands adjourned.
Thank you, Chair.
Thank you, Chair.
Thank you.